Everything explained in this video is summarized from the CoinMarketCap, and also please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now take a look at this. Judge Torres deliberates on ruling. Alderoty weighs on regulation. During the remedies phase of the case between Ripple and the SEC, Judge Torres is involved in deliberating on a final order about penalties and injunctions. Additionally, the parties are reviewing prospective appeals. After nearly reaching the end of July without any movement being made, the XRP army and lawyers are looking forward to a ruling in the lawsuit in the month of August. The experts point out that appeals are probably already in progress in the litigation right after the verdict was handed down by the court. When it comes to appeals in the Ripple versus SEC case, experts weigh in. Due to Ripple's numerous victories, the action against the United States Securities and Exchange Commission is considered by, including wealth advisor Mickle, to be the weakest case there is. On the other hand, as the attorneys pointed out, both parties can challenge rulings that have been made in the past. Several motions are currently being considered by Judge Nelisa Torres and Judge Sarah Netburn. These motions include expert testimony, unsealed documents, and final judgment. According to the assertions of a few attorneys like Fred Rispoli and James Murphy, Judge Torres can circumvent the motions that are presented to Judge Netburn and instead announce the final verdict during the remedies phase in either July or August. Sherry, an expert in Ripple versus the SEC, stated that if the SEC does not appeal the case, it will do damage to all of their other cases involving cryptocurrency. In addition, she inquires as to the reason why Ripple would not submit an appeal against the ruling that OD sales are considered to be securities offers. Through the selling of XRP Odo, the corporation generates a greater amount of revenue. Ripple and the XRP army should not be concerned about the possibility of incurring penalties because Judge Torres will decide the amount along with an explanation. The legal language of an injunction would be the deciding factor which will affect the company's operations. According to Mark Fagel, a former attorney for the Securities and Exchange Commission, the SEC publicly proclaimed its intent to appeal the case. What's more, some things might be speculated about regarding the influence of following instances, changes in policy or strategy, and other similar considerations. If the Securities and Exchange Commission decides to appeal against the summary decision, however, they will be concerned about the earlier interlocutory appeal rejection as well as the risks of escalation to the Second Circuit Court. Controversial position regarding settlement. The settlement in the XRP lawsuit continues to be the most contentious aspect of the case, with conjecture growing after a move by either Ripple or the SEC concerning the settlement. Given the most recent rumors that have been circulating about the SEC's meeting behind closed doors, the comments that Ripple CEO Brad Garlinghouse made during an interview with Bloomberg regarding the lawsuit and settlement between Ripple and SEC made the situation even more hot. Despite this, attorneys such as Mark Fagel and Bill Morgan have dispelled the current claims that a settlement was reached. There had been no discussion on settlements, according to executives from Ripple. Nevertheless, the court would likely allow the parties to meet and discuss the possibility of reaching a solution. Quote Ripple regarding the clarity of regulations, Stuart Alderoty. According to a video that was uploaded to the UI website on July 26, Stuart Alderoty, who is the chief legal officer at Ripple, offered his thoughts on the changing regulatory landscape around crypto assets. The European Union's MiCA, the United Kingdom's Financial Services and Markets Act 2023, and the United States Regulation by Enforcement's policy were the subjects of Alderoty's investigation of the regulatory approaches of the United States, the United Kingdom, and the European Union. When it comes to cryptocurrency, he voiced his discontent with the regulatory and enforcement framework in the United States. Alderoty said that it is a fortunate development that clear regulations are currently being enacted in Congress with bipartisan support. The regulators must have a measured regulation to distinguish between bad actors and good actors, thereby safeguarding investors and ensuring the seamless adoption of technological breakthroughs, echoed Morgan's concerns and opinions regarding the RippleSec deal. Fagel said that the removal of the opportunity to file an appeal following the conclusion of the settlement could be a significant obstacle for both parties in the process of settling. In addition, the former attorney for the Securities and Exchange Commission mentioned the enormous amount imposed by the authorities. There is a possibility that this will be forfeited and the blockchain payments company will most likely be excluded from paying it. The Securities and Exchange Commission demanded a penalty of $1 billion in addition to about $1 billion in disgorgement and interest. This is the only viewpoint that the SEC has brought before the court. Fagel observed that they will not get it. However, the numbers have not changed. Examples of previous cases and their financial implications. In the meantime, Stuart Alderoty, chief legal officer of Ripple, stated that the Securities and Exchange Commission might not be eligible for any entitlements because of the precedent that was set by the Aaron Goebel case. As far as he is concerned, the regulating authority is unable to assert a claim for profit from the seller if the buyer does not suffer any kind of financial loss. According to Morgan, who said in a prior article on X that institutional investors did not suffer any financial loss, this position is consistent with his previous statement. On the other hand, the Securities and Exchange Commission, SEC, asserted in March that investors suffered a financial loss of $480 million as a result of Ripple's alleged discrimination during the sale of XRP on demand liquidity. Key settlement conditions and negotiations have been drawn out, and XRP has been on a bullish rampage. This was something that we briefly covered earlier as of the time this article was written. For investors and cryptocurrency enthusiasts, it is imperative to closely monitor XRP as market analysts suggest that breaking through significant resistance levels, such as the 65-cent level, could pave the way for XRP to climb back to $1 and beyond. This could be a huge win for investors and set a positive precedent for the broader crypto market. The ongoing legal dispute between Ripple and SEC is crucial for XRP and the larger cryptocurrency market. The outcome could result in significant price gains and much needed regulatory support. As always, do your research and think about diversifying your portfolio to manage risks. The market may react quickly and significantly to any positive legal development. Lucidity, making informed decisions about investments, requires keeping an eye on trends and staying informed. Please let me know what you think about the Ripple lawsuit and some of the recent whale activity in the comments section below. I have made an effort to explain to people what closed meetings are, how they function, and the reasons why a settlement, if it existed, probably wouldn't even be scheduled at one, as I was presumably the only person here who used to attend them. I said impact on the settlement, the potential for an appeal by the SEC against the decision regarding programmatic sales of XRP. However, because the price of XRP to go below 0.40 cents. Mark Fagel cautions against having a too optimistic outlook regarding the possibility of a Ripple settlement. Both the CEO and CLO of Ripple continue to have optimism regarding a speedy settlement. Even though there are a lot of unknowns, XRP is currently trading at 598 cents, which is a weekly increase of 7. Mark Fagel, former attorney for the Securities and Exchange Commission, SEC, has cautioned market players about the possibility of an excessively optimistic outlook regarding a prospective settlement in the ongoing legal struggle between the SEC and Ripple Lab. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and have consulting with a knowledgeable professional.